thing go live. Hey, we are live again.
It's all right. We're back. We were just enjoying Becky's ringtones, which is probably more exciting than the talk on Medicaid estate recovery. But the question is, what happens when somebody is living in a nursing home, but they still own a home and they pass away? And there are a couple of different things, but the premise is under the law of estate recovery, which I can give the Ohio Revised Code sections, but I'm not going to. Oh, do you really want to?
It's, my audience will want those numbers.
Okay, Ohio Revised Code 5162.21. Ohio Administrative Code 5160:1-2-07.
And that was the OAC?
The last one was the Ohio Administrative Code, yeah.
OAC.
The Ohio Revised Code is 5162.21. But estate recovery can make claims against someone's probate estate, and they, by law, can place a lien on a home, on real property. And so what happens is either the state recovery makes a claim against the probate estate, so they look and see. I will re-explain the mechanics of how it gets there, but to answer the question directly, I would expect that Medicaid estate recovery would place a lien on the home after your mom passes away. If the property is transfer upon death, then it will transfer to, assuming you and your sister are the beneficiaries, the property will transfer to the two of you, subject to the lien. The state of Ohio,
house payment, right?
Yeah, I'm sorry.
Which would basically mean they have to make a house payment.
No.
You can't pay Medicaid off?
You can settle it, you can negotiate it, you can pay it in full, or they'll just wait until you eventually sell the property and collect. Estate recovery does not have a habit of foreclosing, although theoretically they could, but they don't. And in the cases I've dealt with, I have never foreclosed on anyone that would never be popular with the public to do that. But if you ever tried to get a mortgage, it wouldn't work out, because the mortgage company would see that lien on there and require you to pay off the state recovery lien. If you wanted to sell the property, the lien would be there. It would be paid off before any proceeds of sale.
But if you want to live there, then you can live there.
You would be able to live there. Now, different circumstance. If it's in a probate estate and the property was, a claim was made against the estate, that would be a forced sale. The court would not allow the transfer of the property with the claim being of record with the court. And here's the mechanics of how an estate recovery claim comes about. Someone on Medicaid passes away. The cases, it comes to the attention of the Ohio Attorney General. They farm the case out to a special counsel, and that's one of the local attorneys who's assigned, like the person I work with. And that special counsel sends a letter out to known next of kin or a known power of attorney, or on your Medicaid application, if you're a designated representative, then it would go out, and the letter would say, we're aware that somebody passed away. Did they have any assets? Were they a resident of a nursing home? What nursing home? What assets did they own? Did they transfer any assets, within 5 years of their death? What bank accounts did they have when they passed away? Basically any information, and they're expecting you to answer honestly. And of course, if you don't, then that would be bad news if they later find out.
But
Now-
if somebody wiped accounts away before that, then there's no
Now, do you have
evidence.
30 days to empty those
Right.
accounts or not?
You mean legally?
Yeah.
Are you
Well, yeah,
I mean, you have to abide by whatever the law is for. I mean, if it's a joint bank account, then it's joint, and you have to follow the law with joint. If it's a probate asset, and you have to go through the probate court, then you have to go through letters of administration. Whenever a probate estate, the other way that estate recovery is notified that somebody on Medicaid has passed is that it's built into the probate process. Whenever somebody passes away, on the first page of the standardized Ohio form, it says there's a box to check to tell the court this person was 55 years or older when they passed away and may have been on Medicaid.
what if they're under 55 and they're on Medicaid?
If you're if you're 55 or younger and not permanently institutionalized, the state of Ohio will likely not seek estate recovery.
Oh,
So you have to be a certain age and have to be permanently institutionalized. But they keep track regardless, and if you later become institutionalized, I can't say that they won't seek estate recovery for everything. Because unfortunately, I just don't know.
okay. Well, you know what I do for a living.
I do.
Okay. Same thing with all of us.
Yes.
Okay, we're all Ohio Shared Living Providers.
We're getting to that.
Okay, and the MAGI rule, you're familiar with that?
Yes.
Okay.
But also when you talk about special needs trusts, stable accounts,
Well, that's not where I'm
pooled
going.
trusts,
As a provider, my income is zero because I fall into 2014-7 difficulty of care. Okay, so I pay no taxes. Because I pay no taxes, under the MAGI rule, I am eligible for Medicaid. So a lot of providers like me are now getting Medicaid. That's where I'm going. And a lot of us are over 55.
That's scary.
yeah.
That's where I'm
I
going.
think you're going to be subject to estate recovery.
Okay.
One of the hot button issues right now is if anyone's ever gone on the Obamacare exchange, I just say Affordable
The
Care Act
marketplace.
marketplace. And if you don't have a certain amount of income, it says you qualify for Medicaid, select one of these plans. The state of Ohio actually assesses a premium for that insurance. You would never know that because you don't have enough money to pay one. The only way that you would ever know that, well, you still wouldn't know that because you'd be deceased when you find out. And so, for example, yeah, that is funny. You'd be cursing from heaven.
Hopefully.
Yeah, hopefully. But they keep track, and these are managed care premiums for people who are on Medicaid. And Ohio is seeking recovery for those. And I hear all the arguments about people saying, we had no idea. If I knew, I wouldn't have signed up for that. How could this be? And it's in the fine print somewhere, but it's
That's scary.
when-
I'm going home.
the estate recovery, when they make a claim, you have a right to request what's called the printout. And the printout is a ledger of all the services. And some of them are managed care premiums. And really the only way to be sure is you can email the state of Ohio and request a printout on yourself and say, hey, am I on?
So I could call and get one on Eric if I wanted to?
Yeah, you could say, hey, do you have is he subject to state
Okay,
recovery?
so he's on straight Medicaid. Same
He
thing?
shouldn't be.
Straight Medicaid, even non-managed care program?
You can say, am I subject to a state recovery and what's my printout? And they would tell you.
That'd be interesting to find out how much we spend on our kids, wouldn't it?
But they should know, or if you're not subject, they may just email you back saying, this individual is not subject to a state recovery. Move on.
I have friends in the office of OJF.
But they should know. They do keep track. And
Be
so
interesting, huh?
So what happens is back to the probate process. When you file that application to probate a will or application to be appointed administrator, the court would know that the individual was on Medicaid. And that triggers a court requirement, which is an actual probate form that's standardized. It's Form 7.0. And it requires you to send via certified mail a notice to Medicaid Estate Recovery saying, hey, we think this person was on Medicaid and you have a right to make a claim. And Estate Recovery has 3 months from receipt of that green card to submit a claim.
What if they don't make it?
Sorry, 2 months.
What if they don't make it within that 2 months?
Then they're barred.
Hmm.
But not from putting a lien on a house.
Oh.
So they get 2 bites of the apple. They get the notice requirement, and then they get the opportunity to put a lien on a house. And the lien opportunity doesn't expire.
Oh.
The other, and I'll get into what happens if Medicaid's not notified, and I'll talk about some examples of what I've done in these cases. But typically, the property that's subject to estate recovery, it can be, like I said, real property, life estates, personal property, which is cash, property where there are joint tenants, joint accounts. Technically, that's subject to estate recovery. Living trust assets can be subject to estate recovery with caveats if it's a revocable trust. If it's an irrevocable trust that was created for purposes of qualifying for Medicaid, then not. Special needs trusts have a provision in them. If you've read the fine print, if anyone has a special needs trust, it requires the trustee to pay estate recovery before they distribute to any other beneficiaries.
That's a good question. If you have a special need, it's
Talk
called
about
Safe Harbor
You do
Special
keep your
Needs
voice.
Trust. How, like you were just now stating,
In order to qualify for Medicaid, when you're,
yeah,
I'll use it in
yeah.
if you're younger than 65, you can put assets into what's called a special needs trust.
Uh-huh.
And the rule, what they're allowing you to do is the government says, we'll let you qualify for Medicaid, but you agree to put your assets in this special needs trust. But if you can only spend that money on supplemental services, and that are things that the government won't pay for. So if you're living in a nursing home, you can't say, okay, I want Medicaid and I'm going to kick another $2,000 in from the special needs trust to have a private room. That's a no-go. You can't do that.
Okay.
But what you could do is say, my loved one has a special needs trust. They're in a nursing home paid by Medicaid. I'm going to pay an additional aide to come in after hours to help them with some other services and things. So that you're allowed to do. But the rule is, we'll let you keep this money in the special needs trust and qualify for Medicaid. But if the person passes away with money still in the special needs trust, it must be paid to estate recovery to pay down that, like I said, tab that's accruing. Stable accounts have that provision. Pooled trusts, if you've ever heard of a pooled trust. A pooled trust is similar to a special needs trust, only for people who are over 65. There's a company called Community Foundation Management Fund that will hold the money for somebody so that they can have supplemental money available and qualify for Medicaid. But the Community Foundation Management Fund governs whether they'll pay for the supplemental services you want. and they call it a pooled trust because all of the money for all of their clients are pooled together, but they keep an individual ledger for you. And that has the same caveat where money has to be paid back to estate recovery if they don't spend it all while the individual's alive.
Can I ask you, with that special needs trust or safe harbor trust, if a parent passed and willed money to a younger person, that money goes into that special needs trust. It can stay there and use for, like you said, outside service, outside of that, anything that Medicaid
Yeah,
will not
it won't kick them off their Medicaid benefits.
Yeah, that was
Yeah.
a concern. Oh,
Yeah. So that's and kind of getting a little bit out of track, but that's a common estate planning practice is where parents say, I have a special needs child, but I have other children who are not special needs. I want my child to inherit something, but I don't want it to kick them off their benefits. I trust that my other children will always provide for the special needs child, but I also want something legally there that's theirs. And so they do like a hedge. They'll leave some money in a special needs trust for the special needs child, but then the bulk of their estate will go to the other children, and they just hope that that the other children will pick up the slack if need be, or their parent will haunt them.
yes.
Yeah.
We will.
Excuse me. So, but in my experience with the estate recovery matters that I deal with, it's typically, the most common thing is a nursing home has a resident account that has money left over, where the money that's set aside, Becky, we talked about patient liability, and there's an amount that you get to keep when you're in a nursing home, or that you get to keep as your personal spending amount, that allowance. And that builds up over time in the resident account. And that resident account can be used for funeral and burial expenses, priority number one. And then after that, estate recovery. So the nursing homes by law can pay it to the funeral, for the funeral expenses and burial expenses. And then after that, it has to go to estate recovery. The other common estate recovery items would be cars and homes. The only way a house would not be subject to estate recovery is if the spouse is still alive and living there. Then no estate recovery can be done until that spouse passes away. If you've done, in my guardianship cases, my estate cases, the title companies, everyone knows that when you're selling a property and you have a realtor, and the transaction is going through, they go to a title company and say, hey, will you insure the title to make sure no one can make any claims for the buyer? The buyer there's no one can claim ownership or that they're owed money, and they call it title insurance. So the title companies always ask, is the seller on Medicaid? Was the seller's predeceasing spouse on Medicaid? And that's because they're worried that Medicaid estate recovery will come in and put a lien on the house. And so they always ask. So that's what happens is estate recovery can occur after the passing of the surviving spouse.
Or the disabled child, right?
That's another exception, is if there's a disabled child living in the home, there's no estate recovery. The disabled child's allowed to stay in the home and live in the home.
And they can bring in providers to serve them.
Of course. And so they're not allowed to seek recovery.
I was told that if the disabled child wants to sell the house, they're allowed to sell the house, put that money into like a payback account, and live off that money, and then Medicaid doesn't get any of that money.
Right.
Yes. Okay,
that would
correct.
work. Yeah, because there's no estate recovery while the child is alive and residing there. Yeah.
Okay, so they.
Well, what account could they put their money in?
It'd have to be a special needs
Like a
trust or
special
a
needs
pool
It's
trust.
called it's a special needs payback trust,
Yeah.
basically.
Or Medicaid payback trust is another term for it. Yeah.
So what's the difference? I guess I'm confused with all the language.
Yeah.
Like you said, the payback trust, the special needs trust, then what, the safe harbor trust?
They're all the same thing.
Good.
They're all under the umbrella of a payback trust.
Okay.
And basically what it means is if there's money left over,
Yeah.
we have to pay back Medicaid.
That's right. That makes sense. Okay.
If there's no money left over,
Mhm.
there's no
Okay.
payback.
No.
Like I said, if you don't have anything, you don't pay.
Mhm.
This only comes up when there are assets. And, you know, like it comes up something very innocent.
Mhm.
There's a car in the deceased person's name. And so somebody files a simple probate process, a release of administration. I just did this. The woman who was on Medicaid had a handicapped van. She received Medicaid benefits. She was subject to a state recovery. And we wanted to use the
Do you want some water?
thank you, yes. And the vehicle had to go through probate. And the money, the value of the vehicle is about as much as the burial, the funeral, and the headstone for the woman. And so there's the estate recovery that's out there, and they filed a claim. Now, one of the exceptions to estate recovery are funeral, burial, headstone, those kinds of things. And so Medicaid estate recovery, like I said, I'm a private attorney. I don't handle every estate recovery case. So I deal with Medicaid, the Attorney General's office, just like everybody else does on the majority of my cases. And so what I did is I called the outside counsel and I said, here's the bills for the funeral, burial, and graveside. Some of them have been paid and some of them have not. I want to reimburse the people who paid them, and I want to pay for the gravestone. And they said, sure, send me a waiver and we'll sign off. And so that's how that worked. And so estate recovery waived their rights to potentially seek reimbursement on that money because there was a priority claimant. The priority claimant was the funeral, burial, gravestone, and the like. And so it worked out in that regard. And so that also is an exception. I'm sure if you've had Medicaid planners, you've had Medicaid planners talk to the group, right?
We've had Medicaid come and talk about services, but not planners.
And has anyone talked about when you go to qualify for Medicaid, if you render care in the home for a period of time?
I don't think she talked about that, did she? No.
Okay. If there's a property in the name of someone who needs Medicaid, and like I said, I think Becky mentioned, I more encounter Medicaid when it's elderly folks who need nursing care or assisted living because of my guardianship work and my estate work. But you can transfer a property to an in-home resident who renders care, and there's a process for that.
So if Tammy would have somebody come in the house that was rendering care to her daughter.
They would have to live there.
Okay.
They'd have to be a child or a sibling.
So that doesn't work for you. But it would work for me if I had my daughter move in to take care of her brother.
Yeah.
Like
If your daughter cared for Eric, aside from how your house is
could it
titled.
be niece, nephew, any relative, or how far can you go
sibling.
down?
Sibling or child.
Has to be sibling. Well, not going to be another child.
Yeah.
And what is that for again?
To
Not at my
transfer
age.
the house to the person and ownership of the home.
But if the person is not the owner, the child
the
you take
person
care
on-
is not the owner of the house.
Right. Then it
That's
doesn't
not-
apply. This is where the Medicaid recipient or the person who's applying for Medicaid is the owner of the home. And somebody else changed their residence to move in and care for them. And the
So
theory...
when I get decrepit and I have my daughter move in to take care of me,
Yeah, if you owned a home, then,
okay.
then
She's
you could
already,
transfer.
it's already in a trust, so I don't have to do that, but.
When you buy your other property, your vacation home or something, I don't know.
The one in the Bahamas?
You're right. And the principle is, the idea is that a loved one is coming in to render care. Absent that care, the person would need a nursing home. And the state of Ohio would be paying for that nursing home.
Triple the price.
So, yeah. So they're actually saving money by encouraging people to care for their loved ones in the home. And so that's the idea. But that has to be done at the time of application. That's when that should be done. And there are, of course, a litany of forms that need to be filed in order to do that, which I'm not going to get into today. But I would encourage you to ask if that's something that may apply to you. I would encourage you to ask your caseworker on how to prepare those forms, or seek a consultation from an attorney on how to do that.
What is that? What forms are those again?
Well, I don't off the top of my head, I don't
You don't know the
name of
numbers?
it. No, but there are forms that a doctor is required to file along with the transfer occurring. So you kind of have to do the transfer with the doctor filling out the forms, and then say, whenever, there's a lot to applying for Medicaid, and I know that, that's part of this group, is making sure that you
I
get
have a
access.
Medicaid speaker coming
But
in
you said if they
October.
don't go to a nursing home, then that it shouldn't matter.
Ask the Medicaid speaker about transferring real property and the forms that are required. Basically, you could own a home and be on Medicaid with an intent to return, but you don't want things to be included as what we call countable resources. And you don't want any improper transfers, meaning that you gave money away that could have been used for your care. So in order for it to not be improper, you have to fill out these doctor forms and submit them with the case. And basically the doctor is saying, this person suffered from X, Y, and Z, and they needed the care in the home. Otherwise, they would have been in a nursing home. And that's essentially what the multi-page form deals with.
Okay, so once you're on Medicaid, it's too late to open up some kind of trust, right? Or
Yeah.
can you open a trust and
Sure.
then what happens?
In a case right now that I have, I was going to talk about it. I was going to talk about it as an example. I'm kind of the bad guy in this case, unfortunately. Someone was a victim of a nursing home neglect. They were on Medicaid. And the Medicaid has a couple of different divisions. They have tort recovery, which means when you're a victim and you're hurt and somebody pays for you to get better, they're entitled to get reimbursed for that. If you're seeking, if you sue somebody,
Litigation.
they call that subrogation expenses. If you're going to get hurt, Becky. If you get hurt and I render services to make you better, and you sue somebody to get compensated, when you get paid, I get reimbursed because I helped make you better.
Okay, example, Eric's car accident, his cash settlement, the hospitals took a third, attorneys took a third, and he got a third.
That's
They
subrogation.
basically-
Yeah.
Okay.
Now, in this case, what happened is they settled the case. They opened up an estate. Medicaid found out the person died. They never served the notice on Medicaid. And I called the attorney and I said, hey, your client owes estate recovery. You have to make an allocation in the settlement for estate recovery. And they said, well, we already did. we talked to Medicaid. And I said, no, actually, you only talked to the tort recovery division. You did not talk to the estate recovery division. So the family was going to get some money from the settlement, and now they're going to get a little bit less. And it's currently in the court because, and I understand. I mean, like I said, I have a law practice and I'm on the other side of it. I get it. You're sitting there saying, my loved one was harmed and now we're not even going to get anything, or we're not going to get as much as we thought we were going to get because the government's coming in and they want money back. I understand it. The law is that you're allowed to seek estate recovery, and estate recovery has to be paid, but the outside counsel can negotiate it. So of course I am ready, willing, and able to negotiate. Just like Becky, in your case, the hospital was probably owed a lot more than a third, but they took a third because they were willing to settle it. And everything's negotiable. Estate recovery is negotiable too. They don't have to, but they can, and it's up to the outside counsel to determine how they want to negotiate a particular claim. There are some exceptions for hardship. They're not. You're not guaranteed if you have a hard luck case. Every outside counsel can manage the cases their own way. The only guaranteed ways that estate recovery will waive their lien or waive their right to recovery is for funeral and burial expenses, legal fees, and a fee if you're a fiduciary of an estate. And that's on real property. Now, when you open a probate estate and there are assets that are part of the estate, Ohio law governs the order in which debts are to be paid in that estate. And Medicaid is on that list below many things. For example, I said cost of administration, legal fees, fiduciary fees, burial, funeral, gravestone. Off the top of my head, those are all things, the last sickness, items of last sickness. So if someone was residing in a nursing home on Medicaid and the nursing home was owed money, they would get paid before Medicaid.
Well, they owed back child support. Would that be before?
After.
That would be after Medicaid?
Yeah.
Well, that sucks.
I think they're actually a general creditor.
Oh.
If they're a lien holder on real property, that's different. The lien holders, when you have a mortgage or a lien on real estate, the phrase is, they call it first in time, first in right. The first person to place a lien is in first priority. The next person, the next person. That's why if you ever go to get a mortgage or refinance and you owe debts or something on the property, they will make you pay off the debt before they'll give you the cash out balance of any mortgage, because they want to make sure that mortgage is the first lien on the property. So I talked about different ways that Medicaid would know in when you are a transfer upon death beneficiary of property, you must sign a form indicating whether or not the person you're receiving property from was on Medicaid. And then that goes to the state of Ohio, and then Medicaid estate recovery will then place a lien on the property, even though the property is no longer in the decedent's name. And so I talked a little bit about it. What happens if you open an estate and Medicaid is not notified? Or what happens if you transfer real estate and Medicaid's not notified? Well, a lien would be placed, or what I've had to do in certain cases is file what we call a motion to vacate judgment or a motion to reopen the estate, and then go back against the attorney or the beneficiaries of the estate for not properly notifying Medicaid.
So the attorneys could get in trouble and have to pay that?
Potentially, yeah.
Has that ever happened?
It's always been resolved because there's a big uh-oh moment.
Mm-hmm.
Of course, there's always a difference. What is a failure of the client to tell the attorney? So the attorney has to say, hey, was dad on Medicaid? And if the client lies and says no, then you wouldn't know. But then when a state recovery comes and they say, hey, we're going to sue your client and reopen this estate and we want the money back, then the attorney's going to say, yeah, they're going to sue you. And they'll put a lien on your house, etc. And so those are all things that can happen.
What about like the person's in the nursing home and they're renting their property and they're putting it in their pocket?
Okay, so that's your situation again.
Yeah, I'm pissed.
And I'm sorry.
Because she took everything. She took everything and then stopped us from seeing our mother.
This is for the Medicaid seminar that you're going to have, the Medicaid qualification seminar. And we talk about just a brief overview of what they're going to talk about. You qualify for Medicaid under 2 criteria. One is your total assets have to be below a certain threshold. 2, your monthly income has to be below a certain threshold. The threshold for services goes up or down depending upon what kind of care you need. Obviously, a nursing home, if we've all come across or heard stories about what nursing homes cost, it's really expensive. So if your income is less than that massively expensive bill, you're going to qualify for Medicaid. To answer your question about what is rental income on a property, well, it's a countable resource of monthly income that would go to calculate a patient liability. When you're in a nursing home and you're on Medicaid, the government says, we're gonna help subsidize your nursing home care, and we're gonna pay for part of it, but we're only gonna pay to the extent you can't pay. So if you make $1,000 a month, we want that $1,000, and we're actually going to let the nursing home resident keep $50. If you're a veteran, you get to keep $90.
Are these rules the same in all 50 states, or is every state different?
Every state's different. And I actually had, I have a case where it's a guardianship case, there's no money, but the guy said, if our laws in Texas were the same as Ohio, I'd be my sister's guardian and she would be living in Texas. But they don't do that. What he said is that she gets, regardless of what you think the care level is for Ohio, and every nursing home's different. There are good ones and bad ones. But whatever she could have gotten in Texas, it's exponentially better here. And so it really beat the guy up about it because he felt bad, but his sister's better off here. And so, but that's what they do. They call it the patient liability. So if your mom's getting pension, Social Security, and rent, all 3 of those would be countable monthly resources for calculating the patient liability, and that money should be going to the nursing home every month.
Unless you don't say it. I mean, I don't know it, but I'm just listening
yeah,
to
I mean,
everything I hear.
if you don't disclose it, then, you know, there are some bad things that can happen to you, like getting your mom kicked off of her Medicaid.
I don't know what they're doing, but I'm pissed.
No,
Because I don't see
I'm
my
just
mom,
saying.
but I know that she's doing something.
Hypothetically, if you're
I wanna
on
know.
Medicaid and there's an undisclosed source of income,
Mhm.
then you can be kicked off. And they're gonna come calling for that money, and if it's not there, then there's gonna be problems.
Well, when they ask that question, did they know that she had a house? Would they know to ask?
No, maybe. As I started, when we first started talking, I said, you can own a home and still be on Medicaid. But if you're in a nursing home, you owe a patient liability. So you can own the home, but you won't have access to the money to pay for the home expenses because it's going to the nursing home on patient liability. So that's kind of the rub. That's the tough part about those circumstances where you own a home.
So if you stay in your own home, you're better than going in a nursing home because you don't have that big bill.
Yes.
So if someone comes in and takes care of you and you're on Medicaid, but they keep you in your home, they still are going to come at the end and get whatever they
Yeah.
paid you for the Medicaid.
Yeah.
Do you want to repeat that so they hear that on camera?
So the question was in-home care versus nursing home care. And obviously, yes, it's true that if you're on Medicaid for in-home care, it's a lot cheaper than assisted living and full nursing care. And I get that too, because when people get the printout, they say, you mean to tell me that you want the family to pay the state of Ohio back when this person sat in the house on their phone 4 hours a day and didn't do this or didn't do that? And I said, yes. And the reason why is they're there. And the sad reality is the squeaky wheel gets the grease. If somebody's not a good in-home care provider, you got to say, hey, you're out, or we don't want this person. You know, you have a list of tasks that they're supposed to do. Every one of these places has some kind of a spreadsheet checklist of what jobs they're supposed to perform. And if they're not doing it, you got to get them out. What sucks is, and a sad reality is that, you know, these folks are on contract, Medicaid contract, and it pays, well, you're all providers. You don't get paid what you're worth, you know, and I think that's fair to say, and it's very obvious. And when we had the rampant inflation that we've had, and people can get jobs for $15, $17 an hour, or private pay in-home care goes to $20 to $25 an hour. It's hard when the government's offering 12. And then that's 12.
And we're not all mixed private funds with
Yeah.
Medicaid funds, so you can't make up the difference to keep a provider, like you were saying earlier.
Right. And so shockingly, to nobody's surprise, a lot of companies have gone out of business because they don't have workers who want to work for less money.
And Medicaid doesn't reimburse at time and a half.
Yeah.
So
you have these waiver services, you have these in-home services that are available that you can apply for, but it's very hard to get a service provider to take that case. And it's very unfortunate. The same thing is true of assisted living. A lot of people need help, but they don't need full nursing to be with other folks with dementia and what have you. They need, I can't make meals anymore. I can't go to the grocery store anymore. I can't manage my meds. I've got a buffet every day that I take, and I just need someone to sort that stuff for me. I don't have family locally who can help me, and I just need a more structured environment because I can't do the laundry either. That's assisted living. A lot of people need it, and I'm kind of on a little bit of a high horse because a lot of people need that, and they're not available. It's available private pay, but not Medicaid. Thank you, Eric. Yeah. So I guess what I'm saying is that to circle back to state recovery, remember that it only happens when the person who passes away has assets. Expect that those assets are going to be subject to a state recovery.
And you can't just sell their assets because they'll look back 5 years.
Let me see it again.
You can't just sell those assets because they'll look back 5 years. Like you have two houses, you can't sell one house because it's like, oh, they sold a house within this 5 years.
Well, that's to apply for Medicaid, and that's going to be your Medicaid application talk.
Okay.
The state recovery is after the fact. The state recovery is whatever happened to apply for Medicaid happened, and now the decedent has assets in their name.
But they can't just boom right before they die. I'm going to die in 2 weeks. They can't go in there and sell their stuff. Oh, I was diagnosed with brain cancer. They only gave me 2 weeks to live.
But that's for Medicaid, you said.
Yeah, that's
not this.
the state recovery would look at assets in the decedent's name. Yeah, if some shady things happen, may or may not know about it, but
so then they can get rid of their stuff really quick.
I'm not saying that. I mean, first of all, no. First of all, I mean, legally, it's a breach of fiduciary duty. I should say, Becky, anyone can do anything.
True.
And people do
Yeah,
things.
remember, you can sue somebody for
Yeah.
doing the right thing at the right
Anything.
time if that hurts somebody
But
else.
I'm going back to my thing. So, yeah, whatever she leaves when she dies, that's what then the recovery, they take from there for all the things that they,
Probably a lien.
right?
There's the bottom line is, and it's your case too, whatever assets are in the decedent's name at death are subject to a state recovery. There are some exceptions to reduce the amount due and what's collectible. If it's real property, a lien is going to be placed on the property. If it's a probate estate, then Medicaid is going to want paid to the extent that there are assets there. If there aren't enough assets, they're not going to get paid in full. If, like for example, if the estate is open, you have assets, okay? But let's say it's $20,000 and the person owes estate recovery $100,000. Well, I mean, there's probably not going to be any money that goes to the state of Ohio because, you know, at the cost of a funeral and burial and headstone, the attorneys, we love to be paid too, and a fiduciary fee, and there might be some administrative expenses and court costs. You know, that might eat up the $20,000, and those costs are up here, and Medicaid estate recovery payments down here. So it's still, anytime there are estate assets, I always recommend that you consult with an attorney. If you don't have one that'll give you a free consultation, there are a lot out there. Call your local bar association if you're in a different county.
No, the only thing I really wanna know is would they go after her for the rent that she's taking?
Okay, so you're
And not splitting.
yeah, you're asking a very specific question, and
Cause I know she's.
how I'm
Those are
going
more details.
how I'm going to answer your question, whether you like it or not, is this: if your mom is on Medicaid, rent would be a countable asset, okay, for her patient liability, and if it's not disclosed, she could, and I'm saying ifs and coulds, be kicked off of her Medicaid.
Which means they'd stop paying for the nursing home and
If
mom would be
she's-
kicked out.
If she's
No,
not,
I haven't seen my mom in 9 years.
Is she in
She's in a
Puerto Rico?
nursing home now, so I will not do anything that would, jeopardize her status.
Right,
My
I'm just
sister's
like, is she in Ohio or
It's
is
so
she in
bad.
Puerto Rico?
Yeah, no, she's here in
Is she in
Cleveland,
Ohio? Okay.
but I
So
wanna know that
if
if
she's-
my mother passes away, I could go after her, so she has to then kick that money out. Mhm.
Yeah, and that's a complicated answer.
It is,
Yeah,
but I
and
could.
anyone,
Pay that money back.
anyone can sue anybody for anything.
I know.
And I have a
nowadays.
whole bank of cases of people doing that.
Like me.
Becky, you're a cream puff.
I was,
But-
Just
I was,
better
I
off
was doing
having to
some,
get on Medicaid, basically.
Yes.
If you can never get on Medicaid.
You know, it's there, and like I said, Ohio offers a lot of benefits, and if you need them, take them.
okay.
And if you
You
can,
need them to survive.
and you know, your Medicaid allows you to have assets for a reason. People on Medicaid are allowed to have a home, and they may reside in the home and need Medicaid. Like I said, there's that managed care premium. You may be able to afford to have a house and pay your home expenses and live in your home, but you may not have enough money to have medical insurance. You may be able to reside in your home but need in-home care and you can afford that if the state of Ohio helps bring some people in to help you.
So what if
All
you're,
kinds of reasons. You may have a car to drive around and go places. There are lots of assets you can have that if you pass away, you know, may be owed back.
okay, what if you're on Medicaid for like 3 or 4 years and then you get off Medicaid and you get another job or something with health benefits? How does that work? Do they pay back those 3 or 4 years, or does Medicaid come after you later, or what happened?
Maybe.
Maybe.
Thanks.
So what I did is, and I know everybody hates it when attorneys say maybe, and everybody hates like ifs and coulds and might be's, but the cases are very fact specific. Of course, you have to be subject to a state recovery. And what I did is I had a case where the young lady, it was a medical malpractice case, and the young lady was expected to need Medicaid and need things. Because, you know, when at the time you make a settlement and you put a plan in place, you're fearing the worst. And they did a special needs trust. And the special needs trust had a ton of money in it because they were thinking that she would never, her medical bills would be just off the charts. Well, it turned out that she actually, I mean, she needs a lot of help, but she's in a good way. And she really never needed Medicaid. And so she had all this money locked up in a special needs trust, which is an irrevocable trust subject to Medicaid estate recovery. But in that case, well, you never needed Medicaid. Well, she didn't lose any money, but she never needed Medicaid. She was competent, and she's never going to have any estate recovery. So what I did is I said, well, let's go to court and let's terminate your trust because there's no need for that. Something was done that didn't end up being needed. It's nobody's fault. And so what I did is I named Medicaid as a party to the trust termination, and I said, hey, she's not on Medicaid now, but what's your damage? How much are you owed? And we'll pay you out. So there's no more claims. And that's what we did.
And then the money's hers, what's left.
Yeah. Not subject to estate recovery anymore. Not subject to the rules of the special needs trust because she never needed Medicaid.
And she also came off. She never applied to Medicaid, or she came off of Medicaid.
That was a situation where initially she was on Medicaid and then came off. I think it was like maybe, I can't remember if it was 30 grand or 50 grand that they wanted, and just paid them off and move on.
Can I go back to, you mentioned about the van. My daughter was in an accident and she received a handicapped van. My thing is that in the trust, there's nothing there because they always contribute around that van, this particular van. But now we need for an upgrade in our van for her. could we sell that van? Because every year you got to report, even though it's a zero because we utilize all the money to purchase it. But now it's older. It's an older van.
Yeah.
What would happen if we sell it?
Bless you.
Oh, bless you. And upgrade it. Do I have to go through the probate court, or would I have to file any paperwork? I guess that's the question.
It depends.
Okay. Oh, it depends. I was told that we could sell it.
Okay.
And it would still
Yes.
show a zero balance. then.
Yes, you can sell it
Okay.
and then roll the money into the next vehicle.
Yes.
And you're in a good way.
Okay.
Obviously, depending upon how the van is titled, determines ownership. And so if it's the person who's receiving Medicaid,
Mhm.
there's different reporting requirements than if, let's say, I have a child who needs Medicaid, but it's my van. Well, I don't have to report anything because it's my van. If the van is titled in the name of a special needs trust,
Mhm.
then I do need to report.
Okay.
What if it's titled in the guardianship of?
Then you're subject to the court rules.
Yeah, so I will report it that we sold the van and rolled that money over to a new van.
And if you contribute additional money, the court's probably going to want to know where it came from.
Okay, so then I guess this is the question. If I roll, like you said, we sell the van, get the new van, we report that to the court. At that point, will that trust then be non-involved because it's zero, because it was started with the old van, not the
I
new
see.
van?
Yeah.
That's the question.
If I'm what county?
Cuyahoga, Cleveland.
Okay.
Mhm.
I think that the court would probably allow all of that and it would be fine if the van is titled in the ward's name.
So it would be, the trust then would be,
Is the trust
is it?
monitored by the court?
Yes, it is.
You'll probably have to seek court approval on the sale of the van
Okay.
and tell them what you're doing with the money
Mhm.
and tell them how the new purchase is going to be titled. You're going to have to get them to okay that.
Okay. Should I put the title back in my daughter's name? Or if I take or roll the money over to the new van and put it in my name? I'm trying to figure it out. I'm just trying to get from.
I don't think the
paperwork
court's
to
going to
you.
let you put it in your name.
Okay, but once I roll it over and it say the van is in her name.
That's why I
I'm
said
trying to
it
figure this out.
depends.
Okay.
And just call and talk.
How's the title now?
Do you have an attorney?
But she says it's
It
zero.
said the balance of this count is zero, but it was rolled.
No, how is the van titled?
Or is it her name, my name?
Is it both their
Joint?
names?
Yeah, because I'm
Or-
her guardian. She was the infant.
So it's in the guardianship.
Yes.
Okay, so you're going to have to ask get court authority to,
Expenditure thing.
Yeah.
Like an expenditure thing.
Okay.
Have you ever asked for an expenditure?
Never. I mean, we just kept the van.
It's a
and
simple
been
call the
working
clerks.
with her.
Call the clerks and ask them how they want you to do it. If you had an attorney, of course, call your attorney.
You're right. We did have an attorney we worked with from Columbus, and he said, Audrey, at this point, since the van is older model, just go ahead and sell it, transfer it over, and get your new van, and now it's zero balance.
Yeah, that sounds good.
That's what he said.
Yeah, that sounds great.
And I was
you-
like, fine.
If you,
It's not working.
I'm not going against your attorney's advice, but what I will say is that once an asset is disclosed to the court, and nobody take this to say that you hide things from the
Oh,
court.
no, we don't.
So don't hide
No.
things from the court. But once the court has a record of an asset being part of a guardianship, they don't just let it go away with, oh, I just did this or that
No.
and then forget about it. They're going to ask you to account for it in some manner, and they will, if you go your own way and don't tell them what you're going to do ahead of time, they're going to potentially second guess what you did.
No, I would tell him, for sure.
But if you just tell them ahead of time and say, hey, what's the best way to do this and how to file it,
Okay.
then they'll tell you and it'll be all good.
Okay.
And you're probably not the only one this has happened to. So
Happens all the time.
yeah, they have somebody that's going to tell you something.
Okay.
They have staff
Yeah.
that should tell you. A magistrate should pick up the phone or call you back and tell you. Used to be, before COVID, Cuyahoga County, if anyone's in Cuyahoga County, you could sit there and just wait, and the magistrates would have their door open, and you could walk in and they'd answer questions. Now you have to call, and they'll eventually call you
Porter's
back.
never had that.
They do not.
Every bird like birds.
Portage is not on that list.
No, it's not.
Okay.
But I know we jumped around a little bit. Like I said, estate recovery only governs assets that a Medicaid recipient has at death. So, and you don't owe what you don't have. So, I know we answered questions throughout. If there are other questions, I'll be happy to answer.
Yeah, I was surprised I didn't get any online. I guess I don't want to talk to you, huh?
Probably not. I'm not that
He
excited.
covered everything, it was so good.
Yeah.
Sure.
They fell asleep or they went outside.
No, you
so
had a good
Thank you.
10, 15 people online watching you.
I'm so sorry.
You had the compliance manager from the state of Ohio down in Columbus watching.
They're going to call me and yell at me.
We appreciate you very much.
Yes, we do. You
Yeah.
answer my question.
Sure.
Can you think of another topic for next year? It'll come
He's
to
like
you.
one and done.
I don't know what you guys
Well,
want.
you could bring your dad in and talk about trusts.
About cooking?
Is your dad into cooking now?
Well, he does the gyro lunch at the church.
Oh, well, he used to do
Through the
trusts,
church.
right?
Oh, he was the chief magistrate of the probate court.
Yeah.
Wonderful.
So who does all the elder trusts now? You do all the elder trusts? Wait a second. Janet has a question. No. So the bottom line is, don't put any assets in the client's name.
The same way you put it from
Oh.
the Thomas Road.
You mean,
Basically, don't
mean-
buy anything, put it in their name.
in a Medicaid recipient's name?
Right.
Then I'd say
Yeah.
Hudson,
Okay.
Hudson or.
If there's a rule, you can,
Yeah, take
Once you
Hudson
get to the
or-
circle,
yeah. That's when I was talking about a lot of parents within their
My
estate
daughter's
plans, they
91,
hedge.
I'm
They
Hudson.
don't want their special needs child to not qualify or to have their assets be subject to estate recovery.
The problem is you have to trust your other children to share with
You
that
do.
child.
That's where the haunting comes in.
Yeah.
Haunting?
Yeah.
Maybe we'll all find out one day.
You keep saying irrevocable trust.
That's right, but.
In order for the estate recovery provisions, or in order to protect the assets from Medicaid.
Okay, so the question is, what is an irrevocable trust versus a revocable trust? Okay, go.
All right. The special needs trust, Medicaid payback trusts, pooled trusts are irrevocable, meaning they cannot be revoked or modified without court order. There are some very small, limited exceptions that I'm not going to go into because it's too complicated.
Is
But
it a
generally-
backdoor thing?
Generally speaking, court order to terminate an irrevocable trust. And the reason why is because the idea behind those trusts is that you're allowing people to qualify for things that they wouldn't qualify for if they had unrestricted access to those assets.
Okay, so I was told by my attorney down in Louisville, Alliance, that area, that my irrevocable trust was like a box. That after 5 years, Medicaid's done, I'll take the lid off and look into and see what I own.
Right. And that goes into when you qualify, when you're seeking to qualify for Medicaid, and this is going to be a large topic with your Medicaid planning seminar,
Okay.
is that it is the 5-year look back period. And that's where if you want benefits, you have to, when you go to apply, Medicaid says, okay, what assets did you have over the last 5 years? And if you made any transfers during 5 years, within 5 years of needing services, then they're going to include those as your resources.
Okay. Question, I have an irrevocable trust, you know that. So I win the lottery and I put the money in it. And so my 5 years for that amount of money starts right there, right? When I add something to my irrevocable trust.
Correct.
So, okay, that's why I was wondering.
Yeah.
Wow.
So you can add to an irrevocable trust, you just can't take out of an irrevocable trust, but your time period starts over again with everything you add, not for the whole thing, but just that little bit of amount.
And there are some certain restrictions of age limits of adding assets to payback trusts,
I didn't know that.
but not pooled trusts. So basically, if someone who's receiving Medicaid benefits is coming into some money somehow. I recommend a consultation with an attorney. Like I said, very many will give you free consultations, and it's better to know than ask for forgiveness, because you can plan before. If you have to ask for forgiveness after, you don't want to have a situation where the benefits get terminated. Yeah.
So I had a friend that I recommended. Their mother was getting sick and elderly. I asked him, I said, you guys have an irrevocable trust? And he said, no. I said, you should think about putting everything in an irrevocable trust, because you never know what's going to happen to your mom. Well, they found out how much it was going to cost, and it's usually about between $3,000 and $10,000. Is that about right? Depending on the assets, right?
Okay, so
Okay.
yeah, I have my own thoughts on Medicaid planning,
Okay.
but yes, they charge a lot of money.
Okay, and they decided not to pay that. So then the mother got really, really, really sick about 5 years down the road, and they could not put her in a nursing home because they would have lost the family assets. So they took care of her themselves. So
Yes.
if they had protected those assets beforehand,
Yeah, I
then
mean,
down the road when this tragedy happened, their assets would have been saved.
yeah,
And they could have put the mom in the nursing home to get, and not have to do what they did for her.
yes. So what I will say is that when you talk about Medicaid planning, there are good reasons for it. And the reason why, well, not the reason why, is it can be a very expensive process to do the Medicaid planning. And yeah, the attorneys can charge $5, $10, $15 or so $1,000. And they are very complex, and they involve at times. And that attorney is agreeing. The plan is, we're transferring the assets today and enacting the plan today, so that in 5 years or so, when you need the benefits,
You can apply.
I'm going to apply for you. And I'm agreeing to take that money today and render those services down the road. And that's the general premise. But I will say this, and one of the reasons why I don't do a lot of the Medicaid work that I do involves guardianships where people are already going into a nursing home. The time for the 5-year planning is way over.
Yes.
But from my perspective, there are many nursing homes that are Medicaid only, and the care, meaning that if you only have Medicaid, they will accept you. And then there are facilities that say, we want you to private pay for a period of time, and then when you run out of money, we will keep you in the facility. We may give you a roommate, but we're going to let you stay in this better place. And then there are places that say, the minute you run out of money, you're out on your keister. And so it stands to reason that in those 3 tiers, that the care would fluctuate with the tiers. But, you know, where you're private pay all the way, that care, level of care should be better. You should get better services. Now, obviously, you know, when you're caring for the elderly, you would hope that there is a certain level standard that would be adhered to for everyone, whether you're on Medicaid or not, but I don't know that that's a reality. So at the end of the Medicaid planning process, you have no money and you're going into a Medicaid facility. So you just have to be careful and talk to the planning attorney to make sure that you're setting yourself up for the most appropriate environment. Also, we talked earlier about assisted living, and there's a lot of people who need Medicaid assisted living and not enough beds to meet that demand. So oftentimes the strategy involves deliberately leaving money, a portion of the money, so that you can pay privately for assisted living for a year or two to get into that facility that's better, and then they'll transition you onto Medicaid. So it's not a one size fits all, and you really have to put your planning in.
So
That's
when you're
scary.
looking for an
My
attorney
kid's gonna take
to
them.
do this type of work, should you shop around for the prices?
Yeah, I think, so whenever you're talking about attorneys, it's not necessarily about price. I mean, it's kind of like, yeah, I mean, I'll get a McDonald's hamburger, it'd be all right, but I like the one at Five Guys a lot more. And so price isn't always anything. You've got to get a sense of trust with that person and make sure that they're explaining things. And if you feel that everything's been explained and you feel like you get a good vibe with them, then that's when you'd engage services. And if you're not sure, go have a couple consultations. Go to a couple free seminars. Like I said, these folks charge a lot. They'll talk to you, believe me, because it's lucrative work.
And there's really a lot of people planning to go to a nursing home. I mean, there's people actually planning. Oh my God, that's so serious.
Many, many, many.
Wow.
It is
So
a
sad.
big area of practice. And what the attorneys say is, and it is true, it's not a gimmick, it's true. It is an approved expenditure to pay legal fees. Medicaid will not call that an improper transfer. And if you're saving people money to inherit, it's like, if I told everybody in this room that if you give me $20,000 today, I'm going to give you $100,000 in 2 years. Who wouldn't say that? I mean, okay, yeah, guaranteed. And I'll even show you the bank account where it is, and you can watch it for 2 years. You'd say, okay, I would do that. And so that's kind of what they're saying is, I will guarantee you that you get X amount of money to give to your children or loved ones down the road, and you're going to know where it is in exchange for the legal fees made today. And that's what they tell people. And so it's an easy way to sell that. And it is true. The question is, are you happy with the results of that? And are you happy with how it works out? And unfortunately, it's always a process that you look back on. If Becky, with your friends, if mom or dad never needed the services and they paid the big legal fee and they never needed a nursing home, well, then they're going to say, man, that attorney took us for a ride. If mom or dad needs the nursing home and they pay the big legal fee, they're going to say, wow, I'm really glad we did that. Or in your case, they say mom and dad needs the services. They need to preserve the money. And they say, well, now we have to care for mom and dad in the home because we can't use the money. Yeah. So it's a very, you either have a lot of satisfied customers or a lot of unhappy customers.
Yeah, it's so true.
Yeah. I heard Becky say something like you won a lottery and you put money into the irrevocable trust. Now, does she have to get consent to take money out of that?
Well, she's not in charge of the trust.
No, my daughter is.
Oh, so
There's a back
because
door.
her daughter take money out of it without having.
There is a whole separate seminar of several hours
Really?
that we could do on trust.
I can have him come back like next year. I kind of have everything booked this year, but yeah.
But
If you
what
want-
but
if
it
you
still
want to.
answer the question. Could her daughter take money out of that trust
No.
no
Yes.
matter what?
Yes.
Yeah, she should because she's
Well,
in charge.
I think she's the trustee.
Yeah.
So
Like,
she would,
okay. That's what I want.
she determines.
Yeah.
The trustee is the person who operates a trust.
That's right. Okay.
The grantor or settlor is the person who funds and creates a trust.
Okay.
The person who receives the benefits of the trust is the beneficiary,
That's right.
and they may all be different people.
That's right. Okay.
I was told that there was some kind of back door and that my daughter was able to take money out and that she could give me money if I needed money out of it.
That's right. Okay.
I have not yet needed money. Of course, there's no money in it. It's only my house and some property, but I did it to protect myself in case I ever had to go on Medicaid.
I understand.
And that's why where you get all the maybes and the could be's
I
and the
know.
it depends.
It's all right, it gets so
Because
complex.
all these things depend, especially when you're talking about trusts that are in existence. No one can answer your question unless they read it.
That's right. Okay.
Also, the house, you put it in a trust so that,
My house is listed in my
a
trust.
lot of people have told me that, but you know, I never paid attention because I always felt like they were hiding something,
No,
they do bad things and they want to
I
hide. They
did
want to
it.
hide. So I was scared to do that.
Yeah.
Technically,
So is
I
that true or not?
Yeah, I charge extra for bad things.
But if
No, I mean, there are perfectly legitimate reasons to do.
so I could put my house in my son's
Trust.
as a trust, so that he can.
maybe.
Is that right? I don't understand much
I
about
can't
that.
just answer that question. It's extremely fact specific, and there are all kinds of consequences, good and bad, to doing.
Like
Trust or
I
not
can't
doing
sell my
trust.
house. It would be very difficult to sell my
Well,
house.
that came from
Because it's in
my
the trust.
Right.
brother-in-law, and I know he was doing a lot of crooked stuff, so I never trusted him. He says, "Oh, do that because it's better. Oh, do that," so.
Yeah.
But you're
You
doing
can't.
it.
You
Since I was
can't.
never lying, so I figured, why do it? I'm
I
not.
trust her.
I'm once again. I will go back if anyone's still watching.
Mhm.
I'm going to say it for the whatever how manyth time. Take advantage of a free consultation from a couple of attorneys and ask them in the confines of that consultation all of the facts being disclosed of your situation and get the best advice, because until you do that, you just saying, and I know that's not what you were doing, until you really get into a meeting and get into every single fact, you're not going to know what fact turns the advice. And there's a lot of different ways that the advice can turn based upon this fact or that fact. And,
That's a lot of information.
and there should be, like I said, there's attorneys out there. I know the Akron Bar Association, I think it's a relatively nominal referral fee. I can't remember what Portage's Bar
I have
Association
no
does.
idea.
But I think the attorneys, typically if the bar associations charge you a fee, it's for the bar association. It's not for the attorney.
Do you have a business card?
No.
Yeah, you didn't bring your business card.
I have to, we're going to it's by accident. It just so happens that tomorrow is the senior summit sponsored by the probate court. And I had my staff person take everything to the booth.
Yeah, with your business
So
card.
you guys have been deprived of business cards and
I'm
chip
gonna have you
clips
hold one up to the.
and candy.
Yeah.
And
Oh, and
Yeah.
candy, huh?
You missed out on
Yeah.
chip clip. If you come to
You get
St.
hold your
George's
driver's
Church
license
at
up, you wanna put your
7:30
driver's
tomorrow
license
morning.
up there?
Yeah.
And
St.
George.
George-
A number we can at least reach you if we
Yeah.
want to make a business.
Yeah, and you
can
can always,
contact me.
Can
yeah, Becky can
Oh, yeah.
email you.
Do you do wills?
Yes.
Oh yeah,
Okay, then.
I have them on speed dial on my phone.
Yeah.
Okay.
Yeah, and Becky can forward an email, but
Okay.
Yeah,
that I
it's really
realized
easy.
that
George
earlier
at
today.
our law.
It's George at rjrlaw.net. And but yeah, we have the senior summit tomorrow. That's an all-day, it's legal education sponsored by the probate court, but there's a lot of providers and whatnot. So they have booth sponsors. So all of our promotional materials and things are currently set up at St. George's Church.
I
in
should have given
Fairlawn.
you flyers I hand out about my cruises.
Could have.
I could have, yeah. Shoot.
Right.
Well, that just so happens. But
Yeah.
thank you for sitting through and,
Okay.
and watching. Thanks
I'm
for
going to
coming.
turn this off, okay?